Hello, everyone, and welcome to another episode of Avocats, the podcast where we translate complex international legal frameworks into clear, accessible discussion. Today's topic is one that sits at the intersection of family law, human rights, and international cooperation, the 1980 Hague Convention on the Civil Aspects of International Child Abduction. This treaty has become one of the most important instruments within modern private international law, not because it tells us who should have custody of a child, but because it tells us something even more foundational: which court should decide custody in the first place. In this episode, we will explore how the convention works, why habitual residence is its cornerstone, how Mexico implements its obligations, and what happens when a child is wrongfully kept abroad by one parent. Later, we will walk step by step through a hypothetical case involving parents from Spain and Mexico, and we will examine the procedural, jurisdictional, and conflict of law issues that arise along the way. Finally, we will look at what happens if a foreign decision needs to be recognized and enforced in Mexico. By the end of this episode, you will all have a full understanding not only of the convention itself, but also of the broader legal ecosystem that allows it to function across borders.
To begin, it's important to clarify what the 1980 Hague Convention is and what it is not. Many people assume that the convention settles custody disputes, determines which parent is more suitable, or even analyzes the child's best interest in a substantive way. But in fact, the convention does none of these things. It is not a custody treaty. Instead, it is a procedural mechanism designed to undo the harmful effects of international child abduction by restoring the child to the country where they habitually lived before the abduction or retention occurred. In other words, the convention acts like a reset button, restoring the pre-abduction status quo so that the appropriate court, the court of the child's habitual residence, can decide any custody-related questions. This is because the drafters of the convention recognize something fundamental. The best interests of the child are served when major decisions about their life are made by the courts that actually understand their context, culture, family network, school environment, and daily life. The court of habitual residence is the one that truly knows who this child is. It is not the job of a foreign country to reinvent that context. The convention, therefore, operates on the deeply protective philosophy that abduction itself causes psychological harm and instability. Removing a child from their established environment and placing them in a foreign country, no matter how well-intentioned the abducting parent might be, creates confusion, emotional disruptions, and it can be profoundly traumatic. The convention expresses two major objectives in opening provisions. The first is to ensure the prompt return of children who have been wrongfully removed or retained in any contracting state. The second is to guarantee that custody and access rights established in one country are respected and enforced by others. Through these objectives, the convention discourages what is often called forum shopping, situations when a parent tries to obtain a more favorable custody ruling simply by moving the child to another country. A crucial question arises here. How do we know when a removal or retention is wrongful? Article 3 of the Convention answers this very clearly. A removal or retention is wrongful when it violates a right of custody, including the right to determine the child's place of residence, which was being exercised at the time of the abduction. And here the Convention does something essential. It tells us that we must evaluate custody rights under the law of the child's habitual residence. This means that judges in Mexico, the United States, France, Brazil, or Spain must interpret foreign law to determine whether a parent actually held custody rights. This is one small but significant way in which private international law intersects with the convention, not by choosing which country should decide custody, but by choosing which country's law will be used to define wrongfulness. To make this system function smoothly, the convention requires every state to designate a central authority. In Mexico, as we'll discuss later, that authority is the Ministry of Foreign Affairs through the Directorate General for Consular Protection and Strategic Planning. Central authorities are the heartbeat of the convention. They receive applications, locate children, coordinate with courts, and attempt to secure voluntary returns. The rule ensures that the cross-border nature of adoption cases does not slow the process down. The convention emphasizes urgency. Article 2 requires states to use the most expeditious procedures available, and Article 11 allows applicants to demand explanations if a case is not resolved within 6 weeks. This focus on speed reflects the convention's belief that time is dangerous. Delays can deepen a child's sense of belonging in a new country and make returns psychologically more complicated. The centerpiece of the Convention is undoubtedly Article 12, the prompt return provision. If less than a year has passed between the wrongful act and the beginning of judicial proceedings, the return of the child is nearly automatic. Even after 1 year, return is still the rule, unless the child has become deeply settled in their new environment. The Convention also creates a small and strictly limited set of defenses that can be raised to oppose return. These defenses include situations where the left-behind parent had consented to the removal, where the child faces a grave risk of psychological or physical harm if returned, or when a mature child objects to returning. Courts are instructed to prevent these defenses narrowly because applying them too broadly would undermine the Convention's purpose.
Okay, now that we have a sense of the goals and designs of this convention, it's time to place it within the broader field of private international law. Private international law asks three main questions: which court has jurisdiction, which law applies, and how do judgments travel across borders. The Hague Abduction Convention addresses all three of these questions in an elegant but limited way. The Convention's approach to jurisdiction is straightforward. The courts of the child's habitual residence have jurisdiction to decide custody issues. This means that when a child is abducted to another country, the receiving country cannot decide the merits of the custody dispute. Articles 16 and 19 make this clear. The receiving state's court must focus only on whether the removal or retention was wrongful and whether the child must return. The Convention's approach to applicable law is equally minimalist. The only substantive law it requires courts to apply is the law of the child's habitual residence, but only for determining whether there was a breach of custody rights under Article 3. All of these questions, such as how hearings are held, how evidence is presented, or what procedural rights parties have, are governed by the law of the forum state.
Mexico, as a contracting state, implements the convention through its domestic legal system. The Mexican Constitution plays a central role in the implementation through Article 133, which grants international treaties the force of supreme law, meaning that the 1980 Convention is directly applicable in Mexican territory. Article 4, which enshrines the best interests of the child, guides judicial interpretation of every return proceeding. Mexican civil and family codes define parental rights such as patria potestad and guarda y custodia, which courts rely on when evaluating whether a parent's rights were breached under Article 3. Mexico's central authority is particularly important. The Ministry of Foreign Affairs, through its Directorate General for Consular Protection and Strategic Planning, serves as the liaison between Mexico and other countries. It receives incoming application, forwards outgoing ones, helps locate abducted children, and coordinates with Mexican family courts. The family courts then initiate judicial proceedings, acting with the urgency demanded by the Convention. Their primary job is not to choose between parents, but to determine whether Mexico must send the child back to the country of habitual residence so that the custody dispute can be settled there.
To illustrate how this works in practice, let's consider a hypothetical case. Imagine a 5-year-old girl named Sofia. She's a Spanish national and has lived her entire life in Madrid, where she attends to school, plays with neighbors, and enjoys a stable routine. Her parents, Elena and Ricardo, share parental responsibility under Spanish law. One summer, Ricardo asked to Sofia on a vacation to Mexico to visit his family in Cancun. Elena agrees, trusting that the trip is temporary and knowing that Ricardo has always acted responsibly with the child. But once in Cancun, Ricardo informs Elena that he has decided to stay in Mexico permanently, and that Sofia will remain with him. Elena is shocked. She never consented to Sofia's relocation. She demands the child immediate to return, but Ricardo refuses. At this moment, Ricardo's refusal becomes a wrongful retention under the Hague Convention because it violates Elena's right to participate in the decisions about the child's place of residence. The fact that the Spanish law, being the law of the child's habitual residence, recognizes Elena's custody rights means that her rights have been breached. What can Elena do? The Convention provides her with a clear path. She can initiate the return procedure with filing an application with the central authority in Spain or by submitting it directly to Mexico's central authority. The Spanish law will forward her request to Mexico, where the Ministry of Foreign Affairs must act promptly. The first step will be to locate Sofia. Simultaneously, Mexican authorities will try to encourage Ricardo to return the child voluntarily, which is often the least conventional route. If voluntary returns fail, Mexican authorities will file the case before a family court. In this context, Elena must provide evidence of her custody rights under Spanish law. She must show that Sofia's habitual residence was Spain and that she never consented to the child's relocation. Once the case reached court, the judge will examine the essential facts. Was Sofia habitually residing in Spain? Does Spanish law give Elena custodial rights? If all these elements are satisfied, the Mexican court is generally required to Sofia's prompt return to Spain unless Ricardo established one of the limited exceptions under Article 13. He might argue that Elena consented that returning the child will expose her to serious harm, or that Sofia, if mature enough, objects to going back. These defenses are interpreted strictly. Courts understand that allowing them to freely will reward abduction and undermine the convention.
The Sofia case gives us a perfect opportunity to examine applicable law, the idea of direct international jurisdiction. This concept determines when a country's courts have the authority to hear a case involving foreign elements. In abduction cases, the Convention's jurisdictional structure is intentionally narrow. The Court of Habitual Residence holds substantive jurisdiction to resolve custody. The court of the requested state, like Mexico in our hypothetical scenario, has jurisdiction only to determine whether the child must be returned. Two connecting factors make this possible. The first is habitual residence, which is key to defining custody rights. Since Sofia lived in Spain continuously before her father's retention, Spanish law decides whether Ricardo breached Elena's custody rights. This is why the Convention requires courts to interpret foreign law, because custody cannot be evaluated under the law of the abducting parent's country. The second connecting factor is the physical presence of the child in the requested state. Because Sofia is physically in Cancun, Mexican courts have territorial jurisdiction to order her return. The applicable law system of the Convention is narrow, but it does generate certain difficulties. Determining habitual residence isn't always straightforward. Families sometimes move frequently, parents disagree about whether a relocation was temporary or permanent, and children might have multiple cultural or emotional ties. Courts must assess the degree of integration and stability in the child's life. Additionally, judges must often interpret complex foreign legal systems to understand parental responsibility structures that may not align with their own domestic concepts. This can require translations, expert testimonies, and collaboration between central authorities, all of which may cause delays. Even the 1996 Hague Convention on Jurisdictional Applicable Law Recognition, Enforcement, and Cooperation in respect of parental responsibility and measures for the protection of children provides an elaborate private international law framework for parental responsibility. It does not expand the choice of law rules of the 1980 Convention. Its relevance is mostly to interpret it, helping judges understand what parental responsibility means in foreign legal systems, but its structure cannot override the narrow focus of the original convention, which is limited to determining wrongfulness and ordering the return of the child.
Now, regarding international cooperation and procedural steps, international cooperation is the backbone of the convention. In the Sofia case, the request for cooperation is justified because a child has been wrongfully retained across borders. The convention obligates the states to collaborate to restore the child to the countries best suited to resolve custody. Mexico's central authority receives the application, locates the child, and attempts voluntary return first. Because these cases often involve sensitive family dynamics where negotiation can prevent prolonged litigation. If voluntary return doesn't happen, the central authority must initiate judicial proceedings swiftly. The court then evaluates the wrongfulness under the law of habitual residence. Throughout the process, different transmission channels can be used to exchange documents, including direct central authority communication, consular or diplomatic rules, postal channels, or direct judicial communication. The Convention does not prioritize one method over another. States simply choose the method that best facilitates speed and accuracy. Because Spain and Mexico share the Spanish language, translations are not needed, but in many other cases, certificate translations can be crucial to avoid misunderstandings.
Okay, now regarding recognition and enforcement of the foreign judgment, Mexico handles recognition and enforcement of foreign judgments through Articles 564 to 577 of the Federal Code of Civil Procedures. These provisions establish requirements for jurisdiction, proper notification, reciprocity, and consistency with public order. For homologation and execution to succeed, the foreign judgment must meet the requirements established in Article 571. This includes compliance with the formalities regarding exhortos, exclusion of judgments arising from real actions, jurisdiction exercised in accordance with international recognized rules compatible with Mexican law, with jurisdiction denied if the underlying act contains a clause conferring exclusive competence on Mexican courts. Proper personal notification of the defendant to safeguard due process, confirmation that the judgment has the status of res judicata in its country of origin or is no longer subject to ordinary appeals, absence of parallel litigation between the same parties before Mexican courts unless exhorto or letter regulatory was duly processed, consistency with Mexican public order, and fulfillment of authenticity requirements. Article 572 complements these conditions by specific the documentation that must accompany the exhorto. The requesting tribunal must provide an authentic copy of the judgment, award, or resolution, authentic copies of the records proving compliance with notification and res judicata requirements, translations into Spanish where necessary, and a designated domicile for service and notification within the jurisdiction of the homologating court. Furthermore, Article 571 introduces an additional safeguard. Even when all formal requirements for recognition and enforcement have been satisfied, the Mexican court may still deny execution if it is proven that in the country of origin, foreign judgments or arbitral awards are not enforced in analogous cases. A key principle is that Mexican courts will not litigate the merits of a foreign decision. Their role is purely procedural. They verify whether the decision is authentic, final, or procedural valid. Enforcement may be denied if the case involves matter of exclusive Mexican jurisdiction or if enforcing the foreign decision will violate Mexican public order.
So, as we wrap up this episode, it is important to appreciate the 1980 Hague Convention as a deeply human instrument. At first glance, it may look like a technical treaty filled with procedural rules and jurisdictional provisions, but beneath those technical elements lies a profound commitment. The commitment to protect children from the emotional and psychological harm caused by abduction, and to ensure that decisions about their lives are made by the courts that truly know them. The Convention recognizes that children need stability, continuity, and the support of familiar environments. It also recognizes that custody disputes are deeply personal and must be resolved by the appropriate court, not by unilateral actions or sudden international relocations. By facilitating cooperation between states, promoting prompt return, and limiting exceptions, the Convention provides a framework that prioritizes the child above all else.
Mexico plays an essential role within this system, integrating the Convention into its constitutional and procedural structure and ensuring that children wrongfully brought into its territory receive the protections they deserve. In the end, whether we are talking about Sofia or any real child affected by cross-border disputes, the message is the same. International law works best when it works for the most vulnerable. And the Hague Convention stands as a powerful example of how international community can come together to protect children, restore fairness, and ensure that justice is not restricted by borders.
Thank you for joining us today. If you enjoyed this deep dive, don't forget to subscribe, share the episode, and stay tuned for more explorations of global legal frameworks here on Avocats.
Thank you so much.
Thank you.
Goodbye.
Meow.